May I have your attention, please? The April 22nd, 2025 Liquor Board hearing is now in session. There are no minutes from the previous ones for approval at tonight's meeting, so I'm going to turn it over to Mr. Hurdle, the attorney for the board. Mr. Hurdle.
Thank you, Mr. Chairman. I'm Attorney Abraham Hurdle, counsel to the board. At the beginning of every meeting, counsel makes a few brief announcements. First, the commissioners are part-time public servants and they have outside interests. When they know they have a conflict of interest or the appearance of a conflict of interest, they recuse themselves. They cannot possibly know who will appear before the board at any given matter, which will present a conflict of interest to them. If anybody feels that any commissioner has a conflict of interest in any matter, you have to announce to us as the case is called, and the commissioner or commissioners, as the case may be, will deal with that accordingly. If not, then the commissioners will proceed with all hearings under the assumption that there is no conflict of interest. Secondly, the rules of the board provide that the chair, for the purpose of administrative and judicial economy, can have the board's counsel rule on the admissibility of evidence and objections if there is counsel present and objections are made. The board handles many cases at every hearing, and this assignment allows us to expedite hearings. So rather than the chairman turning to me and me advising the chairman, I'll simply make a ruling, and my ruling will be that of the chair. Chief Inspector.
Thank you, Mr. Hurdle. Okay, two quick announcements before we get started. First, if you haven't already, please, a reminder to silence your cell phones. Thank you. And secondly, if you plan on testifying this evening, you must sign in on the sign-in sheet for your respective case in the vestibule. So if you have not done so, please do so now. Okay, our first case of the night is Latella's Discount Liquor. Vic Corporation, Gurmeet Kaur, President. Sandeep Kumar Mehta, Secretary. Nathan Singleton, Clerk. Detective Middleton, badge number.
Thank you.
Anybody wishing to testify for or against, please solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth. Thank you very much. Detective Middleton, if we could start with you, your name and address for the record, please.
Good evening, Detective Thomas Middleton, Anne Arundel County Police, Western District.
Detective Charles Cepeda.
Gurmeet Kaur, 11507 Fox River Drive, Ellicott City, Maryland.
Sandeep Kumar Mehta, 7931 Myers Drive, Glen Burnie, Maryland 21061.
Thank you very much.
Nathan Singleton, 1609 Golden Chelsea Way, Jessup, Maryland 20794.
Thank you very much. Mr. Hurdle.
Detectives.
Good evening, again, Detective Middleton, Anne Arundel County Police. This incident occurred December 2nd of 2024, approximately 8:10 p.m. Detective Cepeda and I were working Operation Save, conducting alcohol sales compliance checks of retail businesses. We directed a confidential source who we verified through MVA records. I do have a certified copy if needed tonight. Is 19 years of age, entered Latella's Discount Liquors at 2733 Annapolis Road, Suite F, Frank, and that's located in Hanover, Anne Arundel County, Maryland. We observed the confidential source enter the business. CS went into the store, picked out a six-pack of Busch beer, took it to the front counter. The clerk did ask the CS for identification. The CS told the clerk that he did not have his identification with him. The CS was given official Anne Arundel County funds, was able to purchase the Busch beer from the clerk. The CS exited the business, immediately turned over the alcoholic beverages to Detective Cepeda and myself. I know through my training, knowledge, and experience that Busch beer is an alcoholic beverage. Detective Cepeda and I entered the store. We identified ourselves as police officers and identified the clerk as Mr. Nathan Singleton, who's seated all the way down at the end tonight. He was advised of the violation. Mr. Singleton stated, "I thought he was a prior customer. I know I've seen him in here like a year ago." Photograph was taken of Mr. Singleton, the Anne Arundel County liquor license properly displayed. Photograph was taken of the Busch beer and was subsequently destroyed. The clerk was cooperative and the store was not busy at the time of the sale. A copy of the report was then forwarded to the Anne Arundel County Liquor Board, and that would be my statement of facts.
Mr. Jones, do you have any questions? Chairman, any questions?
No questions now.
Commissioners?
No questions.
Mr. Jones?
Nathan, if you state your name, please. Okay, and how old are you?
34.
How long have you been working with Latellas?
Little over 2 years.
Okay, and the 2 years you were working with Latellas, how long had you been involved with the sale of alcohol?
Not that long. I was a stocker
Okay, how long had you been a stocker?
for just about 2 years.
For about 2 years? Okay, and so at the time that you started working at the front counter to sell alcohol, how long had you been doing that prior to this situation?
I believe maybe a month and a half to 2.
Okay. And so when this individual came in, you indicated that you asked the person for identification.
Yes.
Did the person produce any identification?
No.
What did the person say?
He said that I had it in the truck and I was waiting for it.
Okay. And when he said that he had it in the truck, what, if any, response did you give?
I asked for him to go get it, and then he picked up the beer and walked out the store.
And when he picked up the beer and began to walk out the store, what, if anything, did you do?
I followed after him, asking him for the ID and asking for the beer.
Did he stop?
No.
What did he do?
He kept on walking out the store.
And then when he walked out of the store, did you walk out the doors of the store?
No, I turned around and talked to my manager and told him what was happening.
Okay. And at the time that you were at the front counter, were you, for the 2-month period that you had been working as a cashier, had you been working alone at the front counter?
No, I had a manager there working with me.
Okay, was that at all times when you were at the front counter?
Yes.
What happened on this particular time that the manager was not there?
He stepped away for a second to fill out the lottery board, the lottery clipboard, because he closes it up every night.
Okay. And after the person walked out of the store with the liquor, with you yelling for them to stop and looking for identification, did that person ever come back into the store?
No.
At the time that this event occurred, you were not tip certified, is that correct?
No.
Okay. And subsequent to this occurrence, did you go through the necessary course to receive your tip certification?
Yes, sir.
Okay. And showing you, do I need to mark this?
You can mark it as Exhibit 1, and we'll take note of it.
What will be Exhibit 1? Could you take a look at that and identify it for me, please?
This is the tip certification of completion.
Okay, if you could pass that back, please. And subsequent to what has happened in this situation, there was no license verifier with regards to checking licenses for people at Latellas. Is that right?
Yes.
And subsequent to this occurrence, can you describe what Exhibit number 2 is?
It is a ID reader.
Okay, is that what you now utilize?
Yes, sir.
For every sale that goes through that you're a part of, Latellas, you utilize that. Is that correct?
Yes.
Are you now simply working alone, or do you continue to work with someone at Latellas?
I continue to work with my manager.
I have no other questions.
Chairman, any questions?
Yes, I do have a few. Excuse me, give me 1 second. Mr. Singleton, you said you started to follow the subject out of the store, but you stopped before you left the store. Am I correct in saying that?
He was on the other side of the counter, and where I was, I couldn't get out, but I was following right behind him along the counter towards the door.
Understood. Did you say anything to him about stop, come back, anything?
I asked him to stop and leave the beer while he went to go for his ID.
Okay, thank you. The officers, did any of the officers at any time observe Mr. Singleton, the clerk, come out of the building in pursuit of the CI?
No.
And it was no mention of that when we walked in the store. The only mention was that he thought he was a prior customer. But the CS actually, the transaction was committed, with the money was exchanged at the cashier.
Right. So what you're saying is the change was received by the confidential source,
Correct.
and he paid for the beer and he headed out the door. So when you mentioned, Mr. Singleton, the fact that he was going to get his ID and pay for,
He already paid for it first. Before I asked him for his ID, he said he had it in the truck. And I thought I recognized him as a regular who would just pay, go outside, get their ID, and come back in before getting the change.
okay, thank you. I have no further questions.
Commissioners, any questions? Mr. Jones, any rebuttal questions or testimony?
One of the officers, and then I will be done. Officers, did the confidential source here provide any type of written statement with regard to what happened? Was he? Did you inquire? Did you question the confidential source about the encounter that went on in the store? And the questioning that you did of the confidential source, is that what was reduced to writing that's here? This report?
Other than the specific amount, which is a ledger that we submit to account for
And you entered into Latella's, right, to look at it?
Yes.
I mean, traditionally, you've never had a problem with Latella's.
No, no.
So, you know,
Yeah, immediately following the transaction, the CS immediately comes to the car, gets in, and we immediately find out the description of the clerk, whether or not they asked for an ID or not, and we get the change, and then we go in to identify the clerk.
and so when you asked the CS, did he ask for an ID? The CS said
Yes,
that he did ask for
yes,
it.
and I noted that in
Consistent
my
with what
report.
which is consistent with what he's testifying here today, correct?
Right, but there was no mention of a altercation of him trying to stop him leaving the store.
Right. And in Latella's, with the front counter that's there, you're familiar with the location?
Yeah.
The front counter that that the witness is making reference to, it's a front counter that is cut off at the at the point of entry where there are doors. Is that
Correct. Yes.
And so he could follow the person on his side of the counter.
Sure, you could
all the way up
parallel
to
the
door,
walkway, yes.
But would have to jump over the counter in order to
Right.
go through the doors. Is that
Right.
correct?
Correct.
Okay. No other questions with that.
Great. Thank you.
Chair, commissioners, any questions?
No, I have no further questions.
No question.
Hey, anything else you want to say, Mr. Jones?
Your Honor, the only other, Mr. The only other thing that I would present is that certainly Latella's comes in this situation. They've been around for a significant period of time. The clerk that's here, I think that he testified as honestly as he possibly could with regards to what has happened here. When he recognized that he did not have the ID, he took the steps to try to secure the ID. However, that didn't occur and the person walked out the door.
Okay, thank you. Okay, I'm going to go ahead and make a motion in this case. First of all, we have 4 charges. We have charges for sale to minors, sale to a person under the age of 21 years of age, ownership and operation, and cooperation. Now, I believe the cooperation charge extends from the fact that there was an FTA, correct? It was a failure to appear the last time? Correct. Right, okay.
There's
Just
an
one-
alcohol awareness charge as well.
Yes. Okay. This is, in fact, the 5th time that there's been a charge concerning sale to minors within 20 years. Now, let me make this perfectly clear. I said within 20 years. That's a long time, and I know that. And we don't normally consider anything other than maybe the past 5 years. This is your 2nd time within the past 5 years. So I'm going to make a motion that we find you guilty of the first charge of minors because it's the 2nd offense in 5 years with a $1,000 fine and under 21 years of age, sale. We're going to find you guilty of that. That's my motion, of course. And that's a $1,000 fine. Under the ownership and operation, I think it's important that you understand, if you're the owners, the operators, or the manager, you are responsible for what goes on in there. And even though I'm sure he made every honest attempt to correct the bad situation that maybe got out of hand a little too quick, I still find that you're in violation. I am going to go ahead and I'm going to do something I rarely do. I'm going to merge the last two charges together, cooperation and ownership and operation. I'm going to find you guilty of that with a $100 fine. So you have two $1,000 fine motions for sale to minors and under 21, and one $100 fine for the last two that were merged together. That's my motion. Looking for a second.
Chairman, did you have a motion with regards to the third violation of alcohol awareness?
Yes, I'm sorry. I evidently misspoke. Yes, the third and the fourth charge are being merged together, right? And a fine of a total of $100 for those two charges.
My apologies, Chairman. I'm struggling. It's not you. There are 5 charges, 2 of the underage, alcohol awareness, ownership, and cooperation.
Okay, yes, I see you're right. As far as the alcohol awareness, I'm also going to make a motion that we find the defendants guilty in this case with a $100 fine. So that's a total of 2 $1,000 fines and 2 $100 fines. And that's the form of a motion. Looking for a second.
I second the motion.
Thank you. All in favor?
Aye.
Aye. So be it. Be careful, please. All right? And I think you learned your lesson, so.
Yes, sir.
Hope so. Have a good day, everybody.
Thank you very much. Have a nice evening.
Thank you.
Okay, our next case is The Place B. Thank you very much, Mr. Bittner. Anybody wishing to testify for or against, please approach the table and remain standing. And if you could raise your right hands for me, please. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you very much. You may be seated. And Detective Middleton, if we could start with you.
Detective Thomas Middleton, Anne Arundel County Police, Western District.
Good evening, Richard Bittner, BITTLER, on behalf of the licensees.
Pradeep Patel, 8318 Telegraph Road, Odeonton, Maryland, 113.
Thank you.
Karan Patel, 602 Strawberry Row, Severn, Maryland, 21144.
Thank you.
Well, enter denial.
Detectives?
Enter denial to the allegations.
Thank you, Mr. Bitter. Detectives?
On December 2nd of 2024 at approximately 8:30 or 8:30 p.m.
To the reading.
Sorry, overruled.
Detective Middleton and I were working Operation SAVE, which is conducting alcohol compliance checks of retail businesses within Anne Arundel County. We directed a confidential source of 19 years of age, which is verified by their MVA record, to enter the Place Liquors, which is located at 8318 Telegraph Road in Odeonton, Maryland, Anne Arundel County. We observed the confidential source enter the establishment. The confidential source went to the store, picked out a 4-pack of Guinness Stout beer, and transported it to the front counter, sales counter. The clerk at that time did not ask the confidential source for identification. Confidential source was given official Anne Arundel County funds and was able to purchase the alcoholic beverage from the clerk. The confidential source then exited the business and immediately turned over the alcoholic beverages to myself and Detective Middleton. We know through our training, knowledge, and experience that Guinness Stout beer is an alcoholic beverage. Detective Middleton and I then entered the establishment, identified ourselves as police officers, and identified the clerk as Karan Patel. We seated at the table for the black.
Stipulate that.
Okay, thank you, sir. The clerk advised that he was alcohol awareness trained and advised of the violation. A photograph was then taken of the clerk, and the Anne Arundel County liquor license was properly displayed inside the establishment. The licensee was not on scene at the time. A photograph was then taken of the alcoholic beverage, and it was subsequently destroyed. The clerk was polite and cooperative, and the store was not busy at the time of the sale. A copy of this report was then forwarded to the Anne Arundel County Liquor Board. That's all my statement of facts.
Mr. Bittner, any questions?
Thank you. Detective Spada, as indicated, Mr. Patel, the licensee's son, was polite and cooperative.
Yes, sir.
Do you have the verification of the minor's age?
Yes, sir.
Thank you. Given the position that you were on the outside of the parking lot, you didn't actually see the transaction, did you?
I did not personally know.
Thank you. That's all the questions I have.
Chairman, any questions? No questions. Commissioners, any questions?
No question.
Your case, Mr. Bittner.
I will submit. Without argument.
Thank you, Mr. Bittner.
And to be heard in mitigation.
Please go ahead, Mr. Bittner.
As certainly the board is aware, it's a longtime licensee, family operation, father and son, alcohol awareness certified. Dad, who's the actual licensee, was not here at the last hearing. He just simply understood that Karan, being a manager, being an integral part of the business, could appear for him. He had a long prearranged plans to travel back to visit the elderly family in India. So he apologizes for any inconvenience to the board. It wasn't anything intentional. In relation to this particular incident, Karan simply tells me he thought he knew the person. He made a mistake. He's alcohol awareness certified. When we met, and I've known them for many years, and we spoke about, what can we do differently? I have to tell you, there was nothing I could recommend to them to do anything differently. They've got a scanner, they've got signage, and they had been doing everything, given the high volume that they have. This is a hybrid location, it's a packaged goods store as well as a tavern, very active. Except for a COVID violation, if I read your record correct, they haven't had anything in just about 5 years. So I'd ask you to take that all into consideration. Impose a modest fine. It's a family-run operation.
Mr. Chairman, any questions for Mr. Bittner? Commissioners, any questions?
No question.
When it comes to the COVID violation, that was back in August of 2020. But since then, there has been one sale to minor, which was February 6th of 21, and of course, the present day one. There was a couple prior to that, but like I said in the previous case, we only go back approximately 5 years when it comes to looking at repeat offenses and so forth and penalties. With that being said, I'm going to make a motion that being that this is your second offense in 5 years, make a motion to find you guilty of minors under and sale to someone under 21 years of age. And the cooperation, that was a failure to appear in a previous case. I'm going to find you, unless you can explain something that would change my mind, I'm going to find you guilty for failure to appear. We take it very serious here. When we summons you in, we hope you respond. There's many ways you could ask for postponements. I don't think we've ever turned anybody down when they have asked for one. So I'm going to find you, make a motion that will find you guilty of that with a $100 fine. That's a total of $2,100 in fines. Put that in the form of a motion. Looking for a second.
I agree.
Okay, thank you. I have a second. All in favor? Aye.
Aye.
Done.
Thank you very much.
Yep, thank you, and lots of luck in the future.
Hey, that's it.
Thank you very much, gentlemen. Our next case is Blas
We'll wait a little bit
Supermarket.
for that.
Thank you, Mr. Bittner. Anybody wishing to testify for or against for the Blas Supermarket case, please approach the table and remain standing. And just another reminder that if you do plan on testifying this evening, that you must sign in on the sign-in sheet located in the vestibule just outside. And if everybody could please remain standing, I'm so sorry. Thank you. Mr. Blas, if you could remain standing. Thank you very much. Do you solemnly swear and affirm under the penalty of perjury? Pardon me, you need to swear me in. Let's try this again.
You all solemnly declare and affirm on the penalty of perjury, the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
Thank you. Please state your name and address for the record, starting with the chief.
Chief Inspector Jim Ford, Anne Arundel County Liquor Board.
Ma'am.
Chamberlain Health Department.
You're good.
Amanda Savage, Health Department.
Richard Bittner on behalf of the licensees.
Oscar Blas,
Sir, your address, please.
199 Lisa Lane, Glen Burnie, Maryland,
Thank you.
21060.
14 Inglewood City, Maryland, Glen Burnie, 10 to 10, 16.
Thank you. Chief
All right,
Inspector.
I guess it's my turn. Prior to reviewing my report, Mr. Hurdle, I'd like to make a motion that this report and all attached exhibits, which have also been provided to licensee and licensee's counsel, be moved into evidence and become part of the record.
Any objections?
No.
So entered.
And if I may, Mr. Chairman, as I believe the board is aware, my client has ceased operations of the restaurant. And we'll submit on their record. We'll waive a reading. Please.
We're good, thank you.
Chief Inspector.
Yeah, I think I would like to go ahead with the reading of this, Mr. Bittner, if that's okay. This report, activity date was February 5th, 2025. Report date is February 5th, 2025. On February 26, 2025, LaShawn Chamberlain of the Environmental Health Food Division of the Anne Arundel County Department of Health informed me that Blas Supermarket and Deli had been required to remove a bar structure in the restaurant portion of the premise until further notice. Ms. Chamberlain shared correspondence between her and the board-approved manager, Mr. Oscar Blas, with me, dated January 27, 2025 at 8:07 a.m., in which Ms. Chamberlain writes in part, quote, "As mentioned on site, you cannot continue to make changes to the facility without approval," end quote. In a reply to that email from Mr. Oscar Blas to Ms. Chamberlain dated January 29th, 2025, which is attached here too, Mr. Blas attaches a photo to confirm that the establishment has complied with the Health Department directive. On March 5th, 2025, this inspector visited the licensed establishment to confirm that the licensee remained in compliance on this issue. Upon arrival, I was surprised to discover that the bar had been returned to its unapproved position in the establishment. See the attached photos. Board-approved manager Yusari Ramirez Mejia called Mr. Oscar Blas and placed me on the phone with Mr. Blas to discuss. Mr. Blas said it was his understanding that because they were only selling alcohol in sealed containers until they received necessary permissions and permits, that he was able to use the bar that the health department had required to be taken down. This seemed to clearly contradict the correspondence with Ms. Chamberlain. This inspector felt that the licensee's action of returning the bar to its prior position was such an obvious and overt violation of the health department directive that I wanted to pause to double check that I wasn't missing something. I did not have access to email in the field that day due to the countywide IT difficulties, and I felt it wise to reach back out to Ms. Chamberlain at the health department for a reconfirmation of the facts. So I left until I was able to reconnect with the health department for good measure. After leaving the establishment, I was able to connect with Ms. Chamberlain, her colleague, Ms. Amanda Savage, both of whom reconfirmed that the licensee was in direct violation of the health department directive. With this reconfirmation in hand, I returned to the establishment the late afternoon of Wednesday, March 5th, 2025, to direct Ms. Ramirez Mejia, to once again immediately remove the unapproved bar structure and issue violation notice number 1660 for the following violations. 3.202 cooperation, failure of licensee to conform to all lawful requirements specified by the Anne Arundel County Department of Health, specifically replacing the bar when directed to remove until further notice. 3.05 sanitation and safety, failure to operate this establishment in accordance with the requirements of the Department of Health. 3.09 public welfare, failure to operate the establishment in such a manner as to avoid disturbing the health and general welfare of the community. 4.16 unauthorized conduct, performing an act contrary to the rules and regulations of the Board of Licensed Commissioners of Anne Arundel County. And 4.18 alterations, unauthorized and unpermitted alteration and installation on the licensed premise. And this concludes the report.
Mr. Bittner, any questions?
Chief, you indicated that you were surprised when you went to the establishment on March 5th. And that, would you agree with me that that surprise was in part because this establishment hasn't had sales to minors in the past?
Unrelated.
But generally speaking, would you agree with me in terms of operations? There's been a question of alterations to a container out in the back. This has been a violation-free establishment. They tried to cooperate with you and work with you whenever they could. Do you agree with me on that?
I can't agree with you on that because I've been in this position for 2 years, and while friendly and on the spot cooperative, I think this has been one of our more troubling locations in terms of cooperation.
Okay. No violations, no lodge.
I would have to look at the database.
According to your records, they've suffered, except for the storage alterations in October of 2024 and December 31st of 2020, when Mr. Blass, not Oscar, his father, was having a private party after the restaurant was closed. There haven't been any violations in 5 years.
I'll take your word for that based on what you're looking at.
I'm reading the board's records.
Then that would be accurate, yes, sir.
Not seeing that it's been a issue to the public with fighting over serving of alcohol, intoxicated patrons, that type of thing. I don't see any of that in the
I think that's fair.
records. Would that be accurate?
I think that's accurate.
But we agree with you. There have been some building permit issues.
Challenges.
Since COVID, they've been working, trying to get major renovations to the restaurant and the supermarket. You agree with me on that?
I do.
And that they've applied multiple times for permits with the county and faced multiple obstacles with the county trying to get those permits.
I know they've had some challenges.
Thank you. Thank you very much, Chief. I don't have any other questions.
Chairman, any questions for the chief?
No questions for the chief, with the exception of involvement with the health department. Started through communications from them to you. Am I correct in assuming that?
Mr. Chairman, I would have to go back and look because I can't clearly remember how it was initiated. I believe that to be true. I was already working on the previous case when, again, I'd have to look at the email chain that was already started because we were looking at other things as well. And I do believe that Ms. Chamberlain had raised this particular issue with me at the time, and she might remember better than I do.
Okay. I have no further questions for the chief.
Commissioners, any questions for Chief Inspector? Chairman, any questions for any other witnesses or inspectors?
I do actually. This is addressed to even one of the health department representatives. I can recall going back quite a few years where this place has had issues trying to get permits and so forth. I've even gone as far as to work with their attorney and with them to try to help them out. It sounds like you went in there and you observed, and from your observation, you said, this has got to stop at this point. and we need to rectify it immediately or close them down. Am I correct in saying that?
Yes, there had been more than one occasion, so initially in 2000, I believe
I'm sorry,
21.
could she state her name for the record?
LaShawn Chamberlain. Initially in 2021, while we were doing a training exercise / routine inspection was when we encountered a multitude of things. One of which was a small bar that was not approved based on the requirements that we had. Neither of us had been to the facility before. However, based on the requirements of our code, we could say that this was not an approved structure based on the way it was built at that time. It did not have hand washing. That would be primary for us. So we did tell them to only serve bottled drinks. Some time had passed, and I'm just trying to remember the order of things. I know
Of course.
we had some permits applied for in the meantime for an addition of a bar in the facility. That is correct. That was on the far left of the building. What we encountered subsequent in the meantime was us going into the facility and observing a large bar in the center of the facility. So we had now, the smaller bar to the right had been removed, that had restrictions. The larger bar had not been approved as well. It is my understanding from the operator that there were some problems with some final construction regarding sprinklers. But what we encountered was that the bar was mostly finished, but no one had called us for inspection, and that was why they were, I was told anyway, that was why they had made the structure in the middle of the building. But our code requires that you apply for any changes in the facility. So I guess that's where we were, and we've had other instances with things unrelated to the liquor board where changes have been made without approval. Permits have been applied for, but in some cases they've been applied for after the changes have been made, and that's what I can't say they did apply for the bar, but there were some hiccups in the flow of things that presented issues with them being able to move forward to finish.
I understand. Thank you. I have no further questions, commissioners.
No questions.
Mr. Bittner, do you have any questions of that witness?
I do not.
Mr. Bittner, I believe it's your case at this time.
We submit, just like to be heard in mitigation.
Thank you, Mr. Bittner. Now's the time for mitigation.
Thank you. As Ms. Chanel said, there's been hiccups at this place. As the chairman certainly knows, there have been permit hiccups. But as the record reflects, before the board, the establishment has been operated appropriately. They have not suffered any sales to minors. They have not suffered any complaints from the neighborhood. They have not suffered a reputation that would lead this board to give cause and pause for the licensee and the family business to continue. What they have tried to do in the last dozen years since Eduardo Blas, the licensee to my far left, made this his first purchase in the Glen Burnie area, and tried to open one of the first Latin American restaurants and markets in northern Anne Arundel County. He's always tried to expand it. He's always tried to serve his clientele, and he's always tried to follow the rules. And some of those rules are very complicated. And there are times he should have gotten counsel involved sooner. He should have gotten engineers involved sooner. He is an industrious leader of his family, and they thought they could do it. What you heard from the chief was Oscar, the son, who's the chief operating officer of the establishment. He was the one who was trying to figure this out. And we've been trying to figure this out, and I include myself in this, and the board well knows it, for several years to get the proper permits to move the market downstairs, which the county allowed, and expand the kitchen, which they allowed, and expand the restaurant, which, except for the bar, they allowed. So they've tried to work along the way with the process and comply with the process. And they tell me they just simply misunderstood. They were selling in containers, and when we sat down with the extended family, it was, there's no misunderstanding here. You can't misunderstand. It is, and we've talked about this. They not directly, fortunately, the Blas family, but their small country just suffered a serious tragedy with the collapse of a discotheque roof. And we talked about that was a health, safety, welfare issue, and those things matter. So they elected, in consultation, to close the restaurant down till they could get a 3/4-inch water main run across Crane Highway into their establishment so that they could have a proper sprinkler. That's what the whole issue is, and that's what they're willing to do. The significant amount of money that they're willing to invest into the community, into their business, but that's the holdup. Increased water pipe for the sprinkler. We're going to get that done. We're not going to serve anything upstairs. The restaurant is closed. We'd ask you to hold the license until we can come back with all the appropriate permits from all the appropriate agencies and reopen when you feel everything is in order. And we thank you for that.
Chairman, any questions for Mr. Bittner?
So it's my understanding, Mr. Bittner, that your clients have agreed to close the upstairs totally.
Correct. And
Right.
I believe
It's been closed.
It's been closed since
1.5 months.
I'm looking for the date that I notified the board. March 25th is, I believe, the day that they closed before that, but March 25th was when.
Was their official closing. And there's no intention of opening it back up until such time as they get all their final inspections from every department, whether it be inspections and permits, planning and zoning, of course, the health department, fire marshal, everybody.
Mr. Chairman, I've advised them they can't. No matter what they may want to do, they think they could sell it, in a bottle or whatever. No, they're closed.
Okay.
Is that right, gentlemen?
Correct, yes.
Nodding in the affirmative.
And the only thing you are selling downstairs are canned goods and groceries. Am I correct? in
That's
that?
right. No alcohol is sold. It's not even permitted down there. It's not stored down there. No, there's no alcohol being sold on premises currently.
Okay. Have they applied for the 2025 license?
They
Yes.
have.
We already have the new one too.
And it's been issued. It's been issued. I understand.
Okay, so you actually have that in your possession?
Yes.
Okay, thank you.
And we'll bring it back to you. You want it, we'll bring it back.
We will, probably. Mr. Bittner, you know and I know, and they know that we've tried to work with them many times, and I'm not going to go into all that except for the fact that I think we're all aware of the fact that we have tried to work with this Blas family, and Oscar has been extremely helpful and much appreciated. What we have here are charges that are a combination results of an investigation by both the Anne Arundel County Liquor Board as well as the Anne Arundel County Health Department. What I'm going to do is I'm going to make a motion that that we find them guilty on all 5 of the charges, but only assess a fine of $250 per charge. And I'll also order the picking up of the license, the 2025 license, and it's to be held by the Liquor Board until such time as Anne Arundel County and all of its concerning departments are satisfied with what they see out there. We're not going to give a liquor license to an establishment that's not following the rules. Okay?
Thank you very much.
That's a form of a motion. Looking for a second.
I second the motion.
Okay, thank you. All in favor?
Aye.
Aye. so be it. $250 times 5 plus cost, plus your license has to be surrendered expeditiously. I'll let,
Yeah.
They'll bring it tomorrow.
very good, thank you. Okay,
Thank you.
you're excused.
Thank you very much.
Thank you, gentlemen. Our next case is Homewood Suites BWI Airport, MCR. Thank you, Ms. Schreckengast. Anybody wishing to testify for or against, please approach the table and remain standing. Yes, me as well. Thank you. I do. Chief Inspector Jim Ford, Anne Arundel County Liquor Board, and yes, sir. And we're going to do that one more time. If you could just remain standing and raise your right hand for me. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Okay, Mr. Felischauer, if we could start with you, if you could state your name and address for the record, please, and turn on your microphone. I might need to turn mine off. Hold on.
There you go. Scott Felischauer, 404 Forest View Road, Linthicum, Maryland.
Good evening, Leanne Schreckengast with Royston, Muller, McLean, and Reed here on behalf of the hotel.
Hi, my name is Mr. Dante San Antonio. My address is 5232 Abbeywood Court, Rosedale, Maryland. I'm the assistant GM of the hotel.
Nicholas Katsikas, 7 Box Turtle Lane, Sicklerville, New Jersey, 08081.
Greg Meeks, 1603 Waters Reach Court, Annapolis, Maryland, 21409.
Thank you very much. And Mr. Hurdle, before I give my statement of facts, I'd like to make a motion that the report and all attached exhibits, which have also been provided to licensee and licensee's counsel, be moved into evidence and become part of the record.
Any objections?
No objection.
Thank you very much.
So moved.
This activity date was February 21st, 2025. Report date was February 24th, 2025 for Homewood Suites BWI, located at 1181 Winterston Road, Linthicum Heights, Maryland, 21090. On February 21st, 2025, I was informed by Inspector Scott Felischauer with the Fire Marshal's Office that the licensee was not yet in compliance with fire marshal requirements despite multiple warnings from both the Fire Marshal and subsequently the Liquor Board over the last several months. As a result, and pursuant to a warning letter dated January 29th, attached here too, this inspector arrived at approximately 8:50 a.m. on Friday, February 21st, 2025, to deliver violation notice number 1658 for the following violations. 3.01D, ownership and operation. During my visit, no board-approved manager was on the premise. 3.02, cooperation. Licensee failed to respond in a timely manner to address and completely satisfy fire marshal requirements despite multiple warnings. 3.05, sanitation and safety. Licensee is currently operating the establishment in a manner that does not meet fire marshal requirements. 3.09, public welfare. Licensee is currently operating the establishment in a manner that does not avoid disturbing the general public welfare. This concludes the report.
Ms. Schreckengast, do you have any questions for the Chief Inspector?
I have no questions for the Chief Inspector.
Chairman, any questions for the Chief Inspector? Commissioners, any questions? Ms. Schreckengast, it's your case.
Thank you very much. I will begin by admitting to the first violation with not having a board-approved manager on site at the time of the visit. At the time of that visit, Mr. Dante San Antonio was the sole, unfortunately, approved manager, and he was in the Philippines at that time. Since then, we have now filed manager approval forms for 4 managers, including Mr. San Antonio, are now on record with the board. So we do admit to that violation because there was nobody on site at that time. With respect to the other 3 violations, I would ask that they be merged into one if the board decides to find there is a violation. But I do deny that there is a violation at this point in time and would like to be heard in mitigation on that fact.
Please.
Thank you very much. I'm sorry, Mr. Chairman, did you have a question before I proceeded?
Which 2 charges were you talking about?
3.02, 3.05, and 3.09, all 3 of those, because they all relate to the fire marshal's inspection. Thank you very much. As Inspector forgive me if I pronounce your name incorrectly, it's as hard as mine. Is it okay if I call you Inspector Scott? As Inspector Scott will tell you, he's been working with the hotel since late at the fall of last year. The hotel was transferring their fire monitoring system from BPFE to Simplex. And part of that monitoring process required a whole overhaul of their monitoring facility. The hotel was built in 1998, and the equipment did not mesh with what Simplex had to offer, so they decided to do a whole entire overhaul. At which point in time, the hotel realized that their interface was not working. They notified BPFE at the time, and I believe BPFE contacted you, Inspector Scott, if I'm correct, to notify him of the issue. So the hotel self-reported and have been working on trying to get this issue resolved, which also resulted in discoveries of some other insufficiencies within the hotel. There were cracks in some pipes in the sprinkler system that had to be repaired. They have actively been working on these, and I could provide the board with invoices and work orders from the last several months on Cintas coming out, trying to repair the issues. And Mr. San Antonio can testify for the board that they're very frustrated with their contractor at this point in time because they show up to fix something and then they'll be advised that a part is on back order or they didn't bring the proper part. He can fully express to you his complete frustration. This has been reported to the regional vice president to try to put some pressure on Cintas to get this done. Inspector Scott was out there as recently as last week with Cintas to observe what they were doing, and he gave them another 30 days to get compliant with his directive. And so that's where we are right now. We are unfortunately at this point at the mercy of our contractor Cintas trying to get everything rectified.
Chairman, any questions?
I do. Is this hotel presently occupied?
Yes.
And a question, if I may, for the fire marshal. Is this system workable at all?
Currently, it is. It is currently, and it wasn't initially.
Right.
And they've made strides, but we're still ways out, I feel.
Okay, thank you. I understand. No further questions.
Commissioners, any questions? Any follow-up, Ms. Reckengoss?
I have no follow-up.
It's my understanding this has been going on for quite a long time. Am I correct in that, sir?
October of '24 was my initial inspection.
All right, I'm going to make a motion, and it's for all four of the charges. I'm going to make a motion that we find them guilty of both the ownership and the cooperation, sanitation and safety, and the public welfare, because I think they, in fact, at one point or another, have jeopardized, not intentionally, but have jeopardized the public welfare. And I think hotels, no matter how big or how small, need to be put on notice that when you have people residing in there or employees working there, you have to think about them first. As I'm sure the fire marshal will tell you, that's his goal. So my motion is find you guilty of all four of the charges with a fine assessed at $250 per charge, a total of $1,000 plus cost. Looking for a second.
A second.
Thank you, Commissioner. I have a second. All in favor? Aye. So be it. Thank you. Hopefully.
Thank you very much. Okay, so we are now moving on to the protest of
Chief Inspector, I believe we're going to take a brief recess. Is that correct?
Yeah, I think.
Just a brief recess.
Okay, we're going to take a 10-minute recess. Please, everyone, be back in your seats at exactly 5 past the hour. Okay, folks, let's get settled in, please. We're going to resume in just a moment. Deputy Chief, would you mind stepping outside and asking for anybody to come in who is ready to testify or wishes to participate? So folks, what we're going to do first is we're going to get a head count, and we're going to do that for both of the protest cases up front. The protest of renewal for Magathy Inn and for Blair's. I'm going to focus on Magathy Inn first. So I am going to read off names, and if you could please raise a hand to let me know that you're present. These are the names that we have on the record as wishing to testify, either for or against the license renewal. Are we? Yep. Yes, sir. Thank you, Mr. Chairman. Okay, so we will begin. I'm going to start with the protestants for Magathy Inn. James Keller Sr. Is James Keller Sr. present? If so, please raise your hand. James Keller Sr. is not here. James Keller Jr. Is there a James Keller Jr.? Anna Keller. Anna Keller. Caitlin Miller. Caitlin Miller. Sally Taylor. Thank you, Ms. Taylor. Kenneth Taylor. Kenneth Taylor. Christy Miller. Christy Miller. Regina Miller. Regina Miller. Tyler Jones. Tyler Jones. Mr. Todd Taylor is present. Ms. Catherine Bueg Taylor is present. Wanda Higgs. Wanda Higgs. So, Mr. Chairman, members of the commission, Mr. Hurdle, I have 3 protestants.
Just to confirm, Chief Inspector, 3 of the 10 people who signed the initial letter are present? Is that correct?
That's correct. Mr. Administrator, Executive Director? Yes.
You're aware of the fact that all 10 of your protestants must appear on the night of the protest hearing, which is tonight. And I understand you may or may not have any control over each one of them individually, but it appears that we only have 3 of the people that have signed up as protestants in this case. And if that's the case, unless we have a motion or something to change it, I'm afraid we're going to have to dismiss the protest.
Please.
And I'm sorry, before we begin, could we get everybody's name and address for the record, please? I'm sorry.
My name is
I
Ben.
don't believe anybody's been sworn.
At the moment, Mr. Bittner, I think it's just counsel who is testifying, or proffering and making motion.
Benjamin Henry, Henry, on behalf of Todd Taylor and Catherine Buick Taylor. Mr. Chairman, members of the board, I'd like to bring your attention, alcoholic beverages and cannabis section 4-406, specifically subsection B1. If a protest against a renewing license is filed at least 30 days before the license expires, the local licensing board may not approve the renewal without a hearing. More in particular, specifically for Anne Arundel County, pursuant to section 1118-01, Title 4, Subtitle 4, Renewal of Local Licenses, Division 1 applies to the county without exception. It is our position and our interpretation that once the protest renewal is filed, a hearing must be heard regardless of who shows up or not.
Mr. Bittner?
It's clear there's got to be 10 people in opposition who are here live, who live in close proximity. They don't have 10 people, they have 3 people. The hearing is now, you're holding a hearing. Without the prerequisite 10 here before you, the hearing ends.
Mr. Bittner, do you believe that if they had submitted 50 names on their initial protest and 10 of those 50 showed up, that we would proceed today?
Correct.
And that they only have 3 today and therefore they do not meet the sufficient 10 requirement?
Correct.
Mr. Henry, did you have a response?
I do have a response. I'll note there's been no code section cited that 10 people must appear. It's not in the board's rules and regulations. It's not in state code anywhere. The only thing that is required is that to initiate a protest hearing, you must have 10 signatures. That is the requirement. We have that.
Mr. Henry, are you aware that all of the 10 protestants were sent letters indicating that their presence was required this evening?
I did receive copies on behalf of the board. I understand that.
What happened with why are they not here?
I don't know. My understanding, and I can proffer this, is that some of them did not receive it. I don't know.
Objection, not to your proffering, but he said he didn't know, so now he's saying he does know.
To the best of his knowledge.
To the best of my knowledge. I didn't specifically contact them. I don't have the knowledge, but that is my understanding, is that some of them didn't receive it. And even then, I would still continue that this section is specifically under the state code. And there is case law that supports once a protest is filed, it must continue to a hearing. I can cite you the case specifically, and this is for Board of License Commissioners for Prince George's County. It's Bridgeton, 406 MDAP 229 from 2008. And specifically, there is the same requirement. You know, in the same code, the statutory language is essentially the same. Once it is filed, the only difference between Anne Arundel County and specifically the applicable code to Prince George's is there's an additional, it has to be filed before 30 days. In this particular case, it says once a protest renewal is filed, the board must hold a hearing, and they did, and that was upheld. Yeah, and that was during, to clarify, that was after the protestants withdrew the petition. They were still required to hold a hearing.
Mr. Bittner, any response?
Not familiar with that case, but it's been the long practice of this board that 10 persons have to appear because it's a threshold question to test the validity of the petition. Names could be written, addresses could be written, signatures could be filled in. So the board noticed the protestants to appear. They haven't appeared. You're holding a hearing. The hearing is now, it's been called for a hearing, but they have not met the threshold to continue with the protest hearing. And in fact, you issued a ruling last year, and if I can think of the case, it'll come to me in a minute, where very similar circumstances, 2 or 3 people appeared out of the 10. People sign petitions all the time. They don't know what they signed. In fact, there's no integration with this document of what the petition was for. There's no page numbers. The reasons for the protest comments are not contained in the body of the signatures. So that's exactly why there have to be 10 people here protesting who live in the neighborhood. We don't have 10 people, and I'm taking liberty with the term, but 3 people doesn't comport with 406 or 2209, or 406 or 2209.
Mr. Henry, Mr. Bittner, taking into account your arguments and the past practices of the board, including cases that were heard last year where the policy of the board have been well established that 10 of the listed protestants must be present. Here, there were only 10 listed and only 3 of those 10 appeared. This hearing is considered held, and we would dismiss this protest and deny the protest at this time.
Thank you.
Thank you.
Okay, see you later.
Thank you, everyone. Our next protest of the evening is for Blair's London Town Pub and Grill. And I'm going to go through a similar procedure for determining, please, if everybody could make their way to the outside from the previous case. Thank you. So once we have a moment here, we'll begin reading names.
Win no matter how it's cheap.
Okay, we're going to go through the same procedure to see who is here for or against. I'm going to start with the original protest sign-up sheet, which includes the following names. Sarah Larson. Hello, thank you. Yes. Okay, so we know that Sarah Larson is present. Thank you, Sarah. Daniel Stewart, Mr. Stewart. Mary Benedict. Mr. Aronson. Thank you. Not excused. She did make an attempt to, if you were able to hear, to reach out and explain her situation. And yeah, thank you. Liza Howard. Ah. Okay. Okay. Mr. Mike Brown. Thank you. Diana Brown. Thank you. Christopher Mangin. Thank you, sir. Deborah Mangin. Thank you, ma'am. Joanna Flanders. Joanna Flanders. We do appreciate them reaching out with an explanation, but it would not be excused under the circumstances. Frederick Salveson. Thank you.
Mr. Kovahay?
And Melissa Salveson. Mr. Chairman, I have 7 protestants.
Yes, I did receive that. It was in an email. It was a separate protest of the Dr. Fleet. Not part of the, I told Mr. Manson, he had asked if he could email it. I explained to him that. There was only a couple names on it. I understand that, but it's not on the same form. The hard copy that is required.
I would appreciate a notice of that. Thank you.
And sir, so the record is clear. You state your name again, please.
My name is Steve Horvath, and my wife, Tina Grodner, is here with me. We both signed that document saying we're incorporating that. We emailed it to them. They acknowledged receipt of it, but they didn't tell me that I had to do something in writing.
And your wife's name again, please, sir?
Tina Grodner, Grodner.
Thank you, Mr. Horvath. I think it's moot. It still wouldn't bring it
I
up.
understand.
Yeah, but I appreciate.
I
Yes.
hear you.
Yeah, thank you. So I turn it over to the board in light of the absence of 10 protestants.
Just to confirm, Chief Inspector, of the, I believe that I count 12 initial protestants, how many are present?
So I apologize for the delay. There must be 10 people physically present who actually signed the petition in order for the protest to move forward. So who signed the protest? Right, sir. So I'm sorry, sir. So we've already determined that they're not admissible. And so we need to, we have.
Mr. I think has very little to say on this way it's going, but I have a lot to say on this before we reach this decision, because I don't believe the board has considered their own rule 209A that allows, as long as 10 names are submitted in the petition under E, timely, and as long as you have 10 people here, I direct you to 209A, protests against the issuance or transfer any license shall be filed in writing with the board on or before the day fixed by the notice of the hearing or any postponement of such time, or shall be made in person at the hearing. So I submit most respectfully to the board that if there are 10 residents in the vicinity who are here protesting, that's what the board needs. So in response to your question, you just addressed if 50 people signed and 10 showed up, hearing goes forward, I believe. I answered that in the affirmative. Likewise, if 50 people show up and 50 people signed and 9 signers show up, and 1 non-signer shows up under 209A in person and authorizes his protest, or authenticates, if you would, his protest, then you have 10 people. And I believe a proper count here, and I'd like the record to reflect that we have 11 persons. I believe 9 are signers on the protest, and there's two protests that's one protest filed on 2 separate petitions that were sought to be joined in. You heard Mr. Howard and his wife, Ms. Roden, acting pro se, communicated as a member of the public with this public body, put the board on notice that they intended to participate, they intended to object, and they're here objecting. So we've got 11 people, I believe the record will show, in opposition to the protest. Now, the record needs to reflect most respectfully as well what we don't have here. We don't have a licensee. There's no licensee that's appearing before the board. This is not Paige Blair. And for that reason, you should grant the protest without hearing anything. If the licensee is not here in response to an order to be here, nothing has been submitted to the board showing that Ms. Smith...
Mr. Bittner, I think your argument is not...
Early.
I believe it was not ripe.
Thank you.
Mr. Mister, did you have anything in response with regards to the protestants and the signers?
Yes. If I might, for the record, David F. Mister and Mr. Winter and Bartlett representing the prospective license holder seeking renewal. I disagree with Mr. Bittner. I think that expressly that 10 persons...
I'm sorry.
You're not going to let me have argument?
No, I'm going to let you have argument, but I thought Mr. Cavalli was handling this here. Most respectfully.
No problem. Thank you, Mr. Bittner.
The request of my client.
Thank you. Absolutely. I understand. Absolutely.
Thank you. Thank you for reminding me of that. I missed that. Sorry.
For the record, I am recusing myself from this case and was not going to make the ruling just as a preliminary fact. I did represent the applicant or renewal applicant previously. Mr. Kovahay is going to step in my place. I do appreciate everyone's understanding. Thank you.
Mr. Chairman, may I resume my response?
Thank you, David.
Continue.
I disagree with Mr. Bittner, his proposition. Expressly, 10 persons that signed the original protest petition must appear and must be present here tonight. I don't agree with him that if someone comes in person now, even though they never signed the petition, and they want to protest, they claim that they are in the community and have an objection, they do not have standing. And I think that follows the board's long-standing policy and practice in this regard, and it's an overreach. They're not here, they're not present, and as a practical matter, the protestants must comply with the appropriate rules and regulations. If they don't do it correctly, then they're not entitled to recognition for it. And what they're saying is, oh, we didn't really understand, we didn't do it right, please forgive us. It's not the way it works. And for that reason, I ask that the board make a finding that, in fact, this protest must be dismissed because they don't have critical mass tonight.
I'd like to get a confirmation on the head count. Chief, can you confirm that there are 11, counting those two, or?
Yeah, let's do this. If we could have everybody stand up who is here to protest the Magathy Inn. Let's get that count first.
Yeah.
Blair's London Town, I apologize. I think I just got 13, Sean. 7, 8, 9, 10, 11, 12, 13.
Yes, correct.
Okay, great. So total 13. And now, again, if those people who did not sign anything other than tonight out in the vestibule, please sit down. Other than tonight. So if you signed tonight out there, sit down. But if you signed a petition that was submitted to the office, then you would stand up. So you did, I'm sorry. So you did sign, should I read the names again quickly? Okay.
Please.
So.
Please.
All right, so very quickly, Sarah Larson, Daniel Stewart, I have both here. Mary Benedict is not here. Liza Howard, not here. Mike Brown, Diana Brown, both here. Christopher Mangin, Deborah Mangin, both here. Joanna Flanders, Brandon Flanders, Frederick Salveson, I'm sorry, and Brandon Flanders not here. Frederick Salveson is here. Melissa Salveson is not here. So that gives us 1, 2, 3, 4, 5, 6, 7. And then we have 2 more that signed separately, which we discussed. So that would bring it to 9. So we've got those 3 numbers. We have 7. We have 2 additional that expressed a desire to testify, but did so in the wrong manner. And then we have a total of 13 here present to testify if they wish.
And then, I'm sorry, may the record reflect who has appeared in opposition without signing a petition before today, with just signing in today? I think that brings the number to 12. So we had,
I think that was the 13, because
Yeah.
that was the stand up and count. So, of which, by my count, it was 7 on the original list. I'm sorry, was it Mr. Howard? Horvath, that's what I wrote, and somebody said Howard. I should have stuck to my guns. Mr. Horvath and his wife would make 2 more, were 9, and then there were 4 that appeared tonight for the first time and signed the sign-in sheet. That's the count that I have. Correct. Chief Inspector.
4 that appeared and signed in opposition to the renewal of the license, or put it another way, in protest of the renewal of the license.
Yes, correct.
Commissioners have any other questions?
Mr. Chairman, may I just say one more thing? I think we as respondents are entitled to appropriate notice. People showing up at the last minute here at the hearing does not give us an opportunity to be aware of the protest, who they are, or anything else like that. For that matter, to examine their background and see whether maybe they even qualify as being a relevant potential protestant from the community. So people who show up at the last minute, I think, should never be considered if they did not sign the petition timely and have it submitted to the board and then shared with the respondents.
One other question I had, Mr. was Mr. Bittner raised the issue that there is, in his words, no licensee. Just to make sure I understand the factual pattern, a transfer was approved to Ms. Smith in November, and she was the applicant for the renewal. She's applied for the renewal, or is it?
Yes, we have, well, let me go back and share with the board, and the board can take administrative notice of this. My predecessor counsel filed for injunctive relief about a year ago, and in fact, the court order granting the injunction actually instructed the board to transfer the license to Ms. Smith at that time. So I think that's dispositive of that issue. Secondly, she's paid for it, bought and paid for. And I have filed, based upon the board's practice of not accepting renewals after February, a motion for injunctive relief with the Circuit Court for Anne Arundel County this year. And in that, sought that the court appoint Ms. Smith as a trustee on behalf of Ms. Blair to complete the process, to both the renewal, which she was permitted to do last year on behalf of Ms. Blair, and also to do the transfer authorization to complete the transaction. That is pending. It has been, it's my understanding, it has been consented to by counsel for the board. So we're just pending. That has not been granted because Mr. Bittner's filed a motion to intervene in that matter. I don't think they have standing, but it's still pending before the court. I submit to you that Ms. Smith has appropriate standing to be here on behalf of Ms. Blair, and that Ms. Blair does not have to be here. And there's nothing that says that the licensee has to be present at this. The question is, the board needs to consider whether or not the renewal should be granted, and it doesn't require the licensee to be present, as the rule requires the protestants to be present.
Thank you. Any other questions from the board?
May I respond to that? So, on the last point, it's illogical to think that the own licensee is not required to appear at a protest hearing. New licensee is not required to apply for a new to appear for a new application? No. Okay? It's just simply illogical to suggest that the actual licensee does not have to appear before this board, particularly when Ms. Smith is not advanced to you her standing before the board. Ms. Smith is not the contract purchaser. Paige Blair, the licensee, is not the contract seller.
Objection. The board has approved this transfer. There are objections that should have been raised potentially at the transfer hearing. It's dispositive. He can't raise these now. As a matter of fact, the protest and renewal should only consider actions that have occurred from May 1, 2024 to present. And there's nothing. The protest petition discusses matters that happened years ago.
And if we get to that point, we will address that.
That were in fact raised before this board in November at the transfer hearing, and the board did not give them any weight and did not consider them. It's not appropriate to bring up matters that pre-exist that. And I'm just going to suggest that the circuit court has ruled Ms. Smith has standing.
I don't believe that's correct under the order, and I'm looking at it. It's absolutely correct that prior counsel filed for an injunction to allow the filing of a late renewal without Paige Blair's signature. And the court order granted that, and it provided that upon receipt of the appropriate renewal application, all fees, the license shall be renewed, provided that the plaintiff otherwise complies with Maryland law and the rules of the board. So what's happened is the license has never been renewed. It's never been transferred because it can't. The licensee before the board is Paige Blair. Her corporate LLC turned in their charter years ago. She doesn't have a valid tax ID number. She's abandoned the license. There's no privity of contract between Ms. Smith and Paige Blair.
Objection. Again.
Let Mr. Bridges, we'll come back to that. Mr. Mister.
So Paige Blair did not sign the contract of sale of the land to Ms. Smith. Paige Blair did not sign any power of attorney authorizing Ms. Smith to act on her behalf in the administration of the license. there's a document, and I have all these that I can put in to evidence, and I'd like to, for the purposes of the record, at the appropriate time. But there's, Paige Blair is the licensee. Paige Blair is not here.
Well, assuming all that's correct and there's a standing issue, who, in your position, Mr. Brittany, who has the burden of proof in the protest? Is it the protesters or the licensee?
I believe once a protest is lodged and there's 10 or more persons in the vicinity who appear before the board and protested the license, because the license has to be issued under the same guidelines of 10204 of a new license, the licensee has to be here. It's her license. It's Paige Blair's license.
Well, not necessarily. All that aside, the reason I asked that question is, in my mind, it would be akin to you sue someone civilly and they decide to sit it out and don't appear. But if you're the plaintiff, and that would be the defendant's option in that scenario, it would still be the burden upon the plaintiff in that scenario to actually meet its burden of proof. So that's why I ask, that may be all those points as to whether or not Paige Blair needs to be here as opposed to Ms. Smith may in some respects be moot in the sense that Paige Blair doesn't have a burden to meet, whereas the protestants do. And so whether or not it's voluntary or involuntary or what have you, her absence may be without legal significance. And that's why I asked the question as to who you believe has the burden.
The rules you just cited to specifically deal with a default or a failure to answer. There's a procedure that has to be followed to enter default, enter a judgment by affidavit, proper notice, certificate of notice, completely different to this administrative proceeding. This is a licensee before the board. This is a licensee, a punitive licensee before the board, who's not here. And nothing, and last time I'll say it because I don't want to repeat myself and waste your time. Ms. Smith is here baldly. She's got no authority to act on behalf of Ms. Smith. Ms. Smith has not filed for the renewal. Ms. Smith did not sign a contract of sale with, Ms. Blair did not sign a contract of sale with Ms. Smith. She's not here. She doesn't, by her inaction, it demonstrates, I believe, to the board that she doesn't want the license renewed. If Ms. Blair believes Ms. Smith believes she's agreed, she can bring civil action against Ms. Blair. But Ms. Blair never entered into an agreement, Ms. Blair never entered into an agreement with Ms. Smith. There's no such document that can be produced to you today.
But you would agree that this particular license has been transferred, the transfer of the license to Ms. Smith has been approved. However we got from point A to point B, we reached point B. Would you agree with that?
It's approved subject to meeting all legal requirements.
Of course.
And it can never be transferred because the transferring entity doesn't exist. You cannot get, the board will never get a certificate of good standing from Paige Blair's LLC. She dissolved it in 2001. She turned in her tax ID number, her CR number. So it's a legal impossibility to have this license ever transferred. The court in 2024 allowed the renewal to be filed subject to meeting all legal requirements, and thereafter the transfer to be allowed. The court, I don't believe, has the authority to direct the board to grant a license without meeting all other legal requirements. And it's a legal impossibility, I suggest to you, for Paige Blair to transfer this license. It doesn't exist. In fact, it hasn't for years.
Mr. Mister?
Well, shall I say I vehemently disagree with counsel on that. It's not a legal impossibility. Secondly, and this is very important, the protestants have no standing here. The board has already found, in fact, they don't meet the threshold. He's making an argument basically saying, here the protest, even though we don't have standing to be here. So all arguments he raised are not relevant. Also, he's raising issues that had to be raised at the transfer hearing or prior to that. It's dispositive. You can't go back and raise them again now.
Well, as I said, we can get to that if we get past the point.
I don't
One
mean to-
moment, if you would.
Because that's wrong,
So
what you
we're-
just said.
Well, we'll get, if we get to the point of moving forward with an evidentiary hearing, we can get into we'll address the issue of what the board is going to consider. Because certainly we don't want this to be discussing things that happened in 1995. Is that all you had on that point?
Yeah, I think the board's found that in fact they don't meet the threshold, they don't have standing to be here. Anything they have to say is not relevant at this point in time. The protest must be dismissed.
Sir, I'm sorry, no. Sir, no. I'm sorry, you are out of order. Please. Please, there is a procedure to these hearings, and that is not part of it. So you will have an opportunity to be heard later. Thank you.
So the board, in the transfer hearing, did not address these issues. That's the basis of the appeal. The transfer issue, the board ruled that the only issue that they could consider was the fit and proper person, the applicant being a fit and proper person. They never allowed the protestants to address what I believe is a threshold question: is there a license? Because to be a fit and proper person to hold a license, there has to be a license to hold. So that issue has not been litigated. It's not res judicata for the board. You did not allow it.
But it's also, correct me if I'm wrong, that's part of the subject of the appeal of the transfer. Is that correct? So at least in some respect, would you agree that it's effectively the law of the case, at least at the moment, that issue's been addressed as to Ms. Smith's standing? And if the circuit court rules otherwise, then we have to revisit that. But in terms of the board exercising its jurisdiction at this point, it's ruled, I believe, on that issue by granting the transfer. And if the protest of the transfer is granted and the matter's remanded, then that would revisit it. But I'm not sure the board's in a position now to effectively revisit its own ruling on that same issue.
Most respectfully, it's not the law of the case. This is a different case. This is a protest hearing.
I agree, but effectively, the issue you're discussing is whether or not there's standing to, whether or not the license should have transferred in the first place and whether it could have been transferred.
No.
That's part of the issue as I understand you're also addressing now, or raising now.
There is a court order from Judge Wax directing the board to accept the renewal without certain prerequisites, to transfer the license upon meeting all legal requirements. Now, that hasn't happened, so the license has to be renewed again. Ms. Page, most respectfully, doesn't have standing to renew the license. Excuse me, Ms. Smith doesn't have standing to renew the license. Okay? The order from 2024 has expired because we're now in the next renewal period. And the prerequisites required for the board to process a renewal cannot be met. And the number one, they don't have a court order now allowing you to process Ms. Smith's application. That's pending. We have 11 opponents here protesting the license. The licensee is not here.
Are you suggesting that a contingently approved licensee or transferee can never apply for a renewal?
Not when they don't meet the legal requirements. And part of the legal requirements are that there's a license in existence, a transferable license that is not before the board. The transferor cannot meet the requirements. The licensee is not here.
Well, that's what gets back to my other point, is that in terms of what I consider the law, what I think maybe considered the law of the case, is that if that same point applies and the transferor can't transfer the license, that's an issue that would have been considered and would have been resolved at the transfer hearing and was satisfactorily answered. At least the board took the position that the transfer could in fact take place subject to meeting the checklist. And that is part of the subject of the current appeal to the circuit court, is it not?
I don't believe it is. The basis of the appeal is that the board did not address that issue. The board did not allow the opponents of the transferral to put in the documentation that there was no license to transfer. That's the basis of our appeal.
So the resolution of that issue is the subject of the appeal. Maybe I'm misspeaking in terms of saying that the board made an affirmative ruling, but you would agree that the issue, one of the issues to be resolved on the appeal is the resolution of that issue?
Yes.
Okay. Mr. Mister, you're on the edge of your seat.
No,
Okay.
I agree with counsel's position. That's exactly right. And it should not be an issue now for a renewal protest. That's to be decided by the circuit court or any higher appellate court as part of the appeal process, which is still pending.
Questions from the board? All right. So after all that discussion as to those issues, I think the board's ruling that I will make on behalf of the board addresses the threshold question of the 10 protestants. The board's position is that the only protestants that can be counted toward the threshold question of 10 are the 7 who were present that were originally on the list and Mr. Horvath and his wife. The additional 4 persons who are now present and have otherwise perhaps communicated their interest in protesting, but otherwise are not documented in the proper fashion, can't count toward the 10. And so for the reasons addressed by Mr. Hurdle as to the practice of the board, it's the board's position that the protestants have not met the 10-person threshold and that the protest is denied.
I understand the board's ruling, but I'd like to perfect the record.
Certainly.
So if I could just have a minute. I'd like to move in record purposes. This is this closing documents.
For what?
For
No, I object. The protest has been dismissed. There shouldn't be any introduction of any exhibits to support the protest.
I'm entitled to make my record.
Well, I object to the documents. They're not relevant.
So if I
at
may
this
make a
point in time.
profit.
Certainly.
So I may make a profit that it would have been introduced, if permitted, that there was a closing on the real property in question, 726 London Town Road. The seller was Robert W. Blair. The purchaser was S&S Business. The principal for S&S Business was Miss Sharon Smith. Shannon Smith, my apologies. We would put in a purchase and land sale agreement dated February 19th, 2021 between Robert Blair seller and Shannon Smith purchaser for the real property. That document, I would proffer to the board, does not include the sale of the license or the business. It's a real property land contract. Subsequent to that, on June 10th, Robert W. Blair seller and Shannon Smith entered into a restatement and an amendment to the contract of sale that provided that the purchaser will immediately make application with the board to have the existing license transferred. In the event settlement occurs prior to the license being transferred, seller, Robert Blair, agrees in as much seller has the authority to lease the existing license to purchaser on a month-to-month basis until the earlier of either purchaser obtains the license transfer approval or 12 months after settlement. So any agreement she had was not with the licensee again. That would be.
And are those marked and numbered as exhibits?
We object to the exhibits. Again, this is dismissed protest. They're both irrelevant and inadmissible as the protest has been dismissed.
Well, here's what I think I'm going to do, Mr. Misters. For the sake of Mr. Bittner's record, I'm going to allow those in, but I'm also going to allow you, if you can, you can offer a proffer as to the transaction of the transfer and how the license reached Ms. Smith, if you will, for lack of a better word.
Well, as the board probably knows, in many instances, when you have both real estate.
Well, actually, let me interrupt. I'm sorry, what's Mr. Bittner?
I just wanted to finish my proffer for the record.
I'm sorry.
We had also filed with the board a number of exhibits for introduction. A through F were filed on April 11th. G was filed on April the 12th. And so I'd like those exhibits made part of this record because they were timely filed.
Sure. And just to make clear, so to the extent I'm admitting them into evidence, it's only for the purpose of building the record, not to make a ruling that they would otherwise be admissible if we were engaged in a merits hearing at this time.
Well, I believe you already made your ruling.
Certainly. So I just want to make sure that I'm admitting under those limited circumstances, not to suggest that they otherwise would have been admissible. And then, when you're done, I'll allow Mr. to proffer as to the
Exhibit
transfer
A
license.
is a note from Paige Blair that the pub's been closed since June 30th, 2021. Exhibit B, articles of cancellation of the Blair Pub LLC from March of 2023. Controlled sale of alcohol by Paige Blair, August the 6th, 2021. Photographs of the condition of the property since August of 2023. Incident report from the board, April 26, 2024, and March the 30th, 2023.
And I understand, Mr. Part of your objection to those is because they predate the transfer hearing, and your position is they shouldn't be considered because they predate the transfer hearing, and those issues would have been considered by the board. Is that an accurate summary?
That's correct. Anything having to do that contended by the protestants that should have disallowed the transfer should have been brought out and raised. As a matter of fact, I've looked at the transcript, I've looked at the record. The protestants raised all those issues, and the board chose not to find they were relevant to the transfer. So they've already been considered. But I also object to any of these documents being admitted into the record because this protest has been dismissed.
As I say, I'm allowing them over your objection only for the sake of they would have been part of the record, again, not making a ruling that they would be admissible at this time were we conducting a merits hearing. Is there any proffer you'd like to make as to the transfer of the license? To the extent that's an issue raised by Mr. Bittner.
Just that this was both a real estate transaction and a business transaction. It rose out of the parties, the Blairs getting divorced. They both had ownership issues, and we acquired everything and paid for everything.
We being Ms. Smith?
I'm sorry, we, yes, my client, being SNS Business, Inc., of which Shannon Smith is the principal and sole owner.
Anything further?
No.
All right. And that would conclude this hearing.
Thank you very much.
Thank you.
This hearing is now adjourned. Thank everybody for coming.
Some lady didn't like it.
Yeah.